Oh, yay, oh, yay, oh, yay. All persons having the manner form of business before the Honorable United States Court of Appeals for the Fourth Circuit admonish you to draw nigh and get their attention. For the court is now sitting. God save the United States and this honorable court.
Let's be seated. Good morning and welcome to the Court of Appeals. You might recognize there's an empty seat to my left. That's because Senior Judge Traxler, former Chief Judge of this court, will be participating remotely by audio, but he can hear you quite clearly. Can you not, Chief?
I can. Thank you, Judge Wynn.
Excellent. To my right, of course, is Judge Richardson of South Carolina. We have 3 cases. We were here today. We're going to start our argument this morning with United States versus Smart. We will hear from Appellate's counsel.
Good morning, Your Honor, and may it please the court. My name is Jim Thur. I represent Mr. Smart. There are 3 issues before the court principally today. I'd like to start with the Speedy Trial Act one, which, as the court knows, should the court rule in my client's favor, would avoid the need to address the other 2, as it would require remand with instructions.
Well, why is that? I mean, if we found, and we can talk about the Speedy Trial Act, but if we found there's a Speedy Trial Act violation, wouldn't we still be well advised to address the Fourth Amendment issues rather than sending it back, assuming the district court judge is going to do precisely what he has done before? And so we ought to make a call on that, no?
Your Honor, I would be happy for the court to do that. I just note that in Henry, the court did not address suppression after it found the Speedy Trial Act violation and remanded for dismissal with or without prejudice.
Your point is we could, but we need not, is your position?
Yes, Your Honor, that's correct. So the issue here is—
Now tell me, how much time are you going to spend on the Speedy Trial? I'm going to get right to it. I've been a judge for a long time. Tell me a case in which a case is going back on the Speedy Trial Act. I'm not saying it shouldn't be, but how often does that happen?
Well, it doesn't happen often, Your Honor, but Henry is, of course, the example that I'll point to from 2008. And Henry, in evaluating Zedner and evaluating what happened below, remanded with instructions to dismiss, and again, up to the trial court, whether that would be with or without prejudice. And I think the situation we have here, Velasquez, just in 2022, again, in March, which both parties addressed through supplemental briefing, also remanded for dismissal with or without prejudice. So it doesn't happen a lot, Your Honor. I recognize that, but when it happens, as Zedner teaches, if there is a violation, it needs to go back. And I think that's—
Can I ask a question about the Speedy Trial Act, and maybe we want to talk more about the Fourth Amendment, but what is the appropriate remedy? Assuming that if I give you that you have identified a Speedy Trial Act violation, just hypothetically, you say 2 different things as the remedy, neither of which with argument or support for what the answer is. One, you say we should vacate the convictions, plural. And then in another instance, you say we should dismiss the indictment, non-plural, which seem inconsistent, right? Because there are 2 indictments and there are 3 convictions, but you don't explain why any of that. And so if I assume there's a problem with the conspiracy, the initial indictment, there was a conspiracy on the Speedy Trial Act, what do you think the right remedy is? And help me understand why.
Yes, Your Honor, thank you. So as you pointed out, we had the initial indictment and then a superseding indictment, and we contend the Speedy Trial Act violation occurred in the period of the original indictment. Mm-hmm. And I believe— And
you agree that he was convicted by the jury on the superseding indictment?
Absolutely, Your Honor. That certainly— The record is clear in that regard.
And so if we dismiss the original indictment, or we found the district court should have dismissed the original indictment, it wouldn't affect the conviction. Right? Because they're 2 different indictments. They are legally operative. Just because there's a superseding indictment, it doesn't vacate or void the original indictment. They're both individual grand jury actions.
Well, that's true, Your Honor. I do believe, though, that if you look at Henry and the way Henry addressed the violation here—
Did Henry address a superseding indictment?
No, Your Honor.
I didn't think so. I mean, the difference is, right, in all the cases we've talked about, it refers to dismissing the indictment, but there's only one indictment. right? And so when we look at the language of 31, or is it 3161? Yeah,
Yes.
3161, it refers to dismissing the indictment. All right, so great. Maybe you've convinced me that we should dismiss the original indictment. Now, I don't think that matters here, but that's why the remedy seems to make a big difference to me.
Well, Your Honor, I believe that if the original indictment had been properly dismissed on the Speedy Trial Act basis, then the case would not have proceeded. The superseding.
Why not? As long as it was dismissed without prejudice, right? Then the superseding indictment is issued, and everybody agrees that that fixes the problem, right? If the timing was slightly different, there'd be no question it fixes the problem. I just don't know why it doesn't fix the problem for the Speedy Trial Act. Now, Sixth Amendment, totally different story, but we're not talking about that. For the Speedy Trial Act, what I don't understand is why the superseding indictment is affected by your argument at all.
Well, Your Honor, I believe the trial court has to have the opportunity to determine whether to dismiss with or without prejudice. So with the original indictment, it should have had the opportunity to make that decision. It never had. And if it had decided to dismiss with prejudice following the Speedy Trial Act violation on the original indictment, that would have precluded.
Totally fair, but that's now our decision, right? We're looking at that, and we would say, and if we thought it should have been done with prejudice, your argument might hold. But if instead we thought it should be done without prejudice, the original indictment only, without prejudice, then the superseding indictment ought to remedy that.
Well, Your Honor, what Henry teaches, I believe, is that the prejudice or without prejudice determination is one for the trial court after evaluating the circumstances. That's what they did both in Velasquez and in Henry. So while I don't question the court's authority to do what it will, I do believe that prior panels have looked to the trial court to make that determination.
I don't want to totally
Take your time,
monopolize,
Judge
but
Richardson.
can I ask you about the Fourth Amendment
Absolutely.
question? And again, I sort of want to ask a little bit of the same question. Assume hypothetically, or maybe not so hypothetically, that I agree there's a Fourth Amendment problem with the Louisiana stop. Why, first of all, help me understand why that is not harmless with respect to the conspiracy count. But assume I get that. Help me understand why it's not harmless with respect to the two PWID counts from 2018.
Well, Your Honor, so the PWID counts on the entire presentation by the government of its evidence was predicated on the confession extracted from Mr. Smart after the Suffolk stop.
That's the November 18 stop.
Yes, Your Honor.
Okay, all right, so I get that, but stay focused for me. If I just am talking about the 5 kilos, right, from the Louisiana stop, right, I just want to isolate that. I understand we can look at them together, but I wanted to isolate that for just a minute. And I concluded that that was certainly harmful with respect to the conspiracy conviction. But what I'm hard to understand is what plausible connection it's got to the 2018 PWID.
Well,
right, so assume I say, yes, that should be suppressed. The 5 kilos should be suppressed. But now I've got 2 PWID convictions that seem wholly unrelated to a Louisiana traffic stop a year earlier.
Well, Your Honor, I think as the record shows, the course of the investigation was predicated on the Louisiana stop. Agent Smith testified that he corroborated Pittman, the confidential informant, because he knew about the Louisiana stop and the statements made by Mr. Smart subsequent to that stop. And the taint argument that we've attempted to present in the brief is that it carried through. When you look at the subsequent course of the investigation, the GPS monitoring of the vehicles, the trash pull, it's all engendered by, it's all born from the Louisiana stop, which was constitutionally defective, and the statements thereby that were derived.
Like a fruit of the poisonous tree? You're saying, like, if that was illegal, then the fact that motivated future law enforcement action that discovered independent criminal violations, we suppress all of that? I mean, that seems like a pretty broad reading of the what I think you're making is like a fruit of the poisonous tree idea, right? It's not getting from that. It might motivate the actions, but that's not what we think about as the fruit of the poisonous tree, do we?
Well, Your Honor, I agree. It's a stretch, but when you look at what happened subsequently, there was no independent basis. In other words, it was all engendered by the Louisiana stop. And Smith, I believe, testified quite clearly to that, both at the suppression hearing and again at trial, that the involvement through the task force officer Dosky for the May 23, 2018, which was the Pittman controlled by, that was engendered by Smith verifying reliability of Pittman based on the Louisiana stop. But for the Louisiana stop, Pittman was simply an uncorroborated, lacking any indicia of reliability, confidential informant. So,
but law enforcement often uses those informants to do controlled buys, right? You need to have indicia of reliability if you're going to rely on them, their information for a search warrant or something, but not to do a controlled buy, right? I agree. Generally, law enforcement likes to have a reliable informant when they're doing a controlled buy, but that's not a necessary step. Like that, you're importing the idea of an indicia of reliability, which is a search warrant idea relying on an informant, and what's required to use an informant to make a controlled buy, which are two different standards.
Your Honor, I understand the point. When you look at the Pittman controlled buy, the evidence linking Mr. Smart to that transaction consisted only of Pittman saying he believed Mr. Smart was the source of the drugs, but there was no independent verification that he in fact gave the drugs to Mr. Jones, the cousin, who in fact delivered them to Mr. Pittman. So I recognize that I am importing the issue of the taint from a search warrant context, but for Louisiana, the May 23, 18 controlled buy never happens.
But it was Smart who picked up his cousin, took him to the controlled buy.
That's correct, Your Honor. And when you look at what Pittman actually testified to, he testified that Jones said he needed to get the drugs. And there was no surveillance on Mr. Smart showing that he brought drugs to Mr. Jones. He simply went to Mr. Jones's house and drove him to meet Mr. Pittman. Mr. Smart never got out of the car. So there was no evidence other than Pittman and his purported reliability based on the Louisiana stop per Agent Smith that Mr. Smart was the source of the narcotics. And if I could address quickly the issue of the Suffolk stop likewise was dependent upon the Louisiana stop, in that the reason why Agent Smith told Trooper Miller to pull him over was based on Louisiana. That was based on
not just Louisiana, right? I mean, the district court identified a number of other things that supported probable cause, right? I mean, in essence, what I'm hearing you say is subjectively, the 5 kilos motivated this investigation. Totally fair, right? But we don't look at the subjective motivations of officers after Wren, we look at the objective basis, right? And so even if we take away the Louisiana stop altogether, it doesn't matter what that would do to their subjective motivations. We look at whether it's objectively probable cause, which means we look at the May 18, the August 18, the trash pull, all of that information and say, is that probable cause, right?
Yes, Your Honor. But if you look at the other factors there, the August was a consumption quantity of cocaine.
Can you be arrested for mere possession of cocaine?
It's a misdemeanor under the federal.
Which means you can be arrested, which means there's probable cause of a crime.
You can be arrested if it occurs in the presence of the officer, otherwise you need a warrant. I mean, there was no warrant.
The point being is insofar as the additional evidence, this other evidence other than the Louisiana, you bring up this whole business of taint through the poisonous tree. It sort of seems like me for the first time I'm hearing this, but what is it about that incident in Louisiana that taints the kind of factors that the trial court relied on for probable cause otherwise?
Well, Your Honor, if you look at the Suffolk stop, the November 2018 stop, the evidence, the information against Mr. Smart was corroborated by Smith based on statements from Louisiana and him investigating the Houston location that Mr. Smart identified in his statements to the Louisiana police. That then corroborated Pittman. That led to the trash bowl. The trash bowl, the soapbox with some plastic bags of cocaine residue where there was no forensic evidence of cocaine, there was no description. There wasn't even evidence showing that the trash bag from which that box came from had any letters, correspondence, identifying papers of Mr. Smart.
All right, so assuming that wouldn't be probable cause alone, you don't argue that we couldn't consider it along with the other information to determine whether probable cause exists, right?
No, Your Honor, the standard is you look at each factor in isolation, then in the totality. I agree. So in innocuous, the case law is clear. Innocuous facts can, if they're in part of a group, lead to a totality finding. And I have gone over my time.
You have a little time left. Judge Traxler, do you have any questions?
No, thank you.
We will hear from the appellee and we'll come back to you for some additional time. Yeah.
Thank you, Your Honor.
Good morning, and may it please the court, Jacqueline Bashara for the United States. The court should affirm the defendant's convictions for 3 reasons. First, the defendant waived his challenge to the October 2019 continuance. And even if the court reviews, the district court properly granted that continuance in the ends of justice. Second, the district court did not err in denying the motions to suppress because there was reasonable suspicion to conduct the canine sniff during the first stop and probable cause to detain the defendant after the second stop. Third, the jury heard substantial evidence to support the defendant's conviction for drug conspiracy.
Can you start with the first one? I know you focus on waiver, and assume for a minute that I agree with you that the defendant didn't make these arguments in the pro se filing, but the district court ruled on it, right? We don't typically find waiver in a scenario where the district court actually issues a ruling. So the district court doesn't rely on waiver. Right? You didn't argue waiver in the district court. Instead, the district court addressed it on the merits. Why would we find waiver from the defendant in a scenario where the government addressed it on the merits in its response brief and the district court actually issued a ruling on the merits in its order?
Yes, Judge Richardson, this is different from judicially created preservation rules, right? This is a creature of statute. Congress has said that the failure to move to dismiss.
But the statute just says that you have to make a motion. It doesn't say what has to be in the motion, right? It doesn't say you have to make each argument, right? That's the judicially created doctrine. The statute just says that you have to make a motion, right?
But the statute also says that the defendant shall have the burden of proof of supporting such motion. And it's not clear how the defendant could have met his burden based on the October 2019 continuance if he never identified that he had a problem with that continuance. And further, the Supreme Court in Zedner made clear that the statutory waiver requirement serves additional purposes beyond what we think of as traditional preservation rules, right? It assigns the role of spotting violations to the defendant. It conserves resources by preventing the possibility of a late or untimely motion mooting an expensive and consuming trial, and it prevents gamesmanship. But if the court were to treat this as any other preservation rule and review this claim for plain error, it would subvert those purposes, right? It would functionally shift the burden to the district court to comb the record for potential violations to avoid.
Or shift the burden to the district court to rely on waiver where it wants to rely on waiver, right? Where it wants to say, listen, you don't raise any other arguments, so I'm only addressing the arguments you've raised. But if the district court does it, I mean, just do we have cases where the district court has addressed the very argument? The government did not rely on waiver in the district court, and then we find on appeal that the defendant waived the argument? I mean, that just seems like an odd posture. And I understand you think the statute affects this differently, but
Respectfully, Your Honor, I'm not sure at what point the government would have had an opportunity to argue waiver because the defendant just never raised this argument in the district court. He's raising it for the first time now, and that's why we're invoking waiver.
Any other circuit gone in the direction you suggest?
Yes, there are 5 circuits that have adopted this rule. We acknowledge that one circuit in a concurring opinion in dicta suggested that it did not prefer this rule, but otherwise every other court of appeals to have addressed this issue has held that a defendant who doesn't challenge a particular period of delay waives that challenge on appeal.
do any of those involve the scenario where the district court addressed that very issue though? Right? I mean, so I understand your cases are the ones where it's for the first time it shows up here. We've got the different scenario where the district court addressed the issue.
The district court addressed the issue, but still did not pass upon the precise argument that the defendant is raising now.
Did you voice your objection, or the district court addressed it? Did you make any indication that there was a judge? No, that's not correct. It's been waived.
We did not move for reconsideration of the order denying the motion to
Did you bring it to
dismiss.
the district court judge at all? In terms of
No, Your Honor, because we didn't know that there would be any subsequent argument with regard to that October 2019 continuance.
well, there is, because now you're making an argument that it's been waived.
Because the defendant is raising a new argument in this appeal,
It was given to us by the district court.
not this precise argument.
Why don't you move along? Let's see where we go with the others.
Yes, Your Honor. Unless the court has other questions as to the speedy trial.
Yeah, I do. So assume for a minute that I disagreed with your waiver argument, and so we got to the merits. I understand you to argue effectively that there are sort of 2 steps that have to happen here. One, there's got to be balancing, and I understand you to rely upon this ends of justice demand language, and let's assume that I agree with that. But the second step is that there've got to be findings on the record. And those findings can come later, right? We get that. And here the district court judge made some findings, but I'm having a little hard time understanding how we can rely on those. Because the district court says that the defense lawyer would have needed more time to get ready for trial given the voluminous discovery in the case. But I can't figure out how the original district judge could have possibly known about voluminous discovery, right? So that's an issue that only came up after the continuance was granted, right? There were no discussions in the record that I could find about discovery. And so we know that couldn't have been the reason the original judge was relying on, because the original judge couldn't have known about the voluminous discovery. Help me understand how I square that. The later judge has to be reflective of what the original judge did, and the original judge couldn't have been relying on voluminous discovery, could it?
I'm not sure about that, Your Honor, but it is the Judge Novak's subsequent findings are consistent with Judge Allen's grant of the continuance because of the nature of when it was granted. It was granted simultaneously with the order granting the first attorney's motion to withdraw. So this isn't a situation like Henry, where the continuance was at just a status conference, or Velasquez, where it was after an arraignment and there was just no thought, no discussion about trial preparation. Here, there was a trial date on the books, and the district court determined, based on her assessment of the case, that counsel needed more time to prepare for trial. We know that's a substantively valid consideration. So the fact that the district court might have elaborated on that after the fact doesn't undermine the validity of the findings that the initial district court judge made, at least in her mind at the time that she granted the continuance.
Proceed.
I'm happy to move on to the Fourth Amendment issues if Your Honors prefer. Tilford had reasonable suspicion to conduct the dog sniff during the Louisiana stop based on the totality of the circumstances. First and foremost, he saw a gas can next to the defendant inside the car. And he testified, which the district court found credible, that Tilford had seen gas cans inside cars before. And in his experience, drug traffickers bring gas cans with them when going to pick up drugs to avoid having to stop. In addition
If you
to
see a gas can in the back of a car, you can stop it. You can search it.
Your Honor,
Does it matter who the individual is?
it doesn't
Grandma-
matter who the individual is.
Grandma's right around with a gas can, same thing happens.
No, Your Honor, but we have to look at the context, right? This wasn't sort of maybe a local road where you could be going home to fill up a lawnmower or something like that. This is interstate travel. And also, it's not just the gas can. We've got the inconsistent statements about his travel plans and then the defendant's excessive nervousness and evasiveness.
Can you explain I understand the officer testified to it, and maybe I just have to accept that, but can you help me understand the logic behind it? I mean, because what he testified to is that you carry the gas can so you don't have to stop.
Mhm.
But he's by himself, so he can't like keep driving and use the gas can to fill it up. He's still got to stop, right? I guess I'm having a little trouble with the basic logic, right? So if he said he doesn't want to stop at a gas station, all right, fine. But if he just doesn't want to stop, he's still got to stop, right? Each time, I mean, to empty the gas can into the car, he's got to stop. And so I had a little trouble understanding the logic of why the gas can was indicative of drug trafficking. Can you explain it to me?
So I'm just inferring from the same record that you are, Your Honor, but my understanding is that perhaps it's quicker to just fill up the gas yourself on the side of the road rather than having to pull off to a gas station. And
How much gas was in the can?
it was a full 5-gallon gas canister that's at JA 404. And we know after the fact there was a second can in the trunk as well.
How much gas did he have in the car?
There were 2 cans.
I mean, how much on the needle of the car?
Oh, that's not in the record, Your Honor.
What if it was filled? What if the car was full and where's he going to?
I don't think that affects the reasonable suspicion analysis. The officer didn't testify that he could see the fuel gauge.
Gas and we like to reach out and make inferences, but this applies to anybody. I mean, whether you got a lawnmower or not, you got a gas can based on where you're going with this, and that gives you probable cause.
No, Your Honor, we're not asserting probable cause.
Is who he is?
No, we're not. No, Your Honor. This is reasonable suspicion, not probable cause. And
reasonable suspicion. I search for this. I'm jumping ahead. But that's where we are.
But there were other factors as well, right?
Why do you need this Louisiana stop? You heard the question Judge Richardson asking. Why are you going there? Why not just?
Well, sure. I'm happy to argue harmlessness. We agree that any error in the admission of the 5 kilos.
I'm not trying to make you happy. I'm just trying to decide why you're doing it. Why are you making the decision to go here if it appears that there is independent evidence from the second one, including the confession that's here, that would be supportive of it from that perspective?
I can move on, Your Honor.
Before, just to make sure that I understand the argument, you argue about this sort of inconsistency in travel plans.
Mm-hmm.
But when I look at Tilford's testimony, he doesn't even mention that in his suppression testimony. Can I even consider that? I mean, or how can I consider that? I mean, it's like a statement in your record. It's like a passing reference you can hear on the audio of the stop, but like it's hard to follow why it's inconsistent. It might be hard to follow why it's inconsistent, period, but certainly from the clip on the audio. What is the evidence on which I could rely on an inconsistent travel plan, given that your officer didn't even testify about it?
So there were 2 pieces of evidence that were before the district court on this point. First, the defendant, when he testified in support of his motion, conceded that he lied to Tilford about where he was going. This is at JA 168. He was describing the stop. He said Tilford asked him about.
Totally fair, but that doesn't go to whether Tilford could determine at that point in time that it was objectively inconsistent, right? So
Okay,
I could tell an entirely consistent story, but lie about it, right? And so if I was just lying, that wouldn't show the story was inconsistent at all.
In addition to the defendant's testimony, the government introduced into evidence as an exhibit at the suppression hearing Tilford's police report, in which he recounted that the defendant first stated he was traveling from Lake Charles, Louisiana, where he visited family and was on his way.
Rely on hearsay statements made by a testifying witness when the government could have asked the testifying witness the very thing? I mean, it's plainly hearsay, right? You agree that's not substantive evidence.
Right, but the ordinary rules of evidence do not apply at suppression hearings. The defendant has never objected to the district court's consideration of the police report. In fact, the defendant also introduced the police report.
Totally fair, but like, I don't know, it makes me wonder whether that police report is like reliable, at least, given the relaxed rules of evidence, given that Tilford, when he's asked the question by the government, like, why did you do this? He lists off all these things and none of them is that. Right? I mean, it sort of suggests to me that he doesn't even believe it.
Well, Your Honor, we have to remember that the suppression hearing occurred about 4.5 years after the stop. The police report was a contemporaneous recollection of the stop.
And totally fair. And so if the U.S. attorney, the AUSA had refreshed his recollection, right, provided the report to him, right, a past recorded recollection, we can tell all kinds of stories about how the government could have gotten evidence in that was reliable for that, but it doesn't seem to.
I hear you, Your Honor, but of course, this was a fact finding the district court made, and so on clear error review, certainly the only evidence in the record confirms that his travel plans were inconsistent.
Speak to the nervousness. So there's extreme nervousness. There's a video that we have here. Looks clear, at least to me, from the video, that at some point he's not behaving nervously. In fact, he walks to this police car and he responds to police commands and follows his direction. He does so without delay. Does the nervousness that would form the basis for a reasonable suspicion have to be continuous throughout? Or can an individual initially be nervous and then subsequently be calm, let's say, and yet that initial nervousness be the basis for reasonable suspicion?
Well, Your Honor, we would contest the defendant's new argument in reply that his nervousness subsided.
I'm looking at the video. I'm talking about the video.
I hear you, Your Honor, but the video
said it's a factual determination here. And that factual determination is supported by this video here. Here's to be rather clear. He's not extremely nervous in that latter part of that video. The question being whether he is or not, does that affect the analysis if in fact at some point an officer stops, and it would be reasonable that in any traffic stop, I don't care who you are, a person can be nervous if an officer stops you on the road. And then after you begin to talk, you begin to calm down some. How then do we then say, well, extreme nervousness as being the basis for it? Which is used quite often. And in a certain circumstance that would indicate it depends greatly on the individual. There are a lot of people who would just break down crying if a police officer stops them. And how does that then become the basis for a reasonable suspicion simply because there's a natural human reaction that's shared by so many others? And in this video, as you said, you could test it, but the video is just here.
Your Honor, I would just urge that the defendant, first of all, waive this argument because he never raised it in the opening brief. It was raised for the first time in reply. He never made this in the district court, even though he testified in support of his motion. He never argued that his nervousness subsided. I don't believe that the video shows that his nervousness subsided because we don't have a relevant comparator. We cannot see what occurred during the interview before he exited the car. And in fact, I would submit that the district court's finding was not clearly erroneous.
The court can look at a video and determine whether there's evidence that an individual is nervous.
Not this video, because we can't see the first part of the interaction.
If you have a video of an individual, do you think a court is in a position to say If there's testimony, this individual is extremely nervous, it's not shown on this video.
No, Your Honor, I would just add that, so under the Supreme Court's decision in Carroll and this court's decision in Hahn, the court can also consider evidence deduced at trial in trying to determine the correctness of a suppression ruling. And in fact, Tilford's testimony at trial indicates that the defendant's nervousness did not subside. He was recognizing, as Your Honor was getting at, that most people, the average person, is nervous when they're stopped by a police officer.
Can you help me understand the sort of the similar question I had about the travel plans? I mean, when I read Tilford's, at least suppression testimony, I have a hard time finding extreme or excessive nervousness, right? I mean, he says it was very clunky, right? It was deliberate answers.
Yes.
Right? So that part I get.
Yes.
Right. But what I don't see, or maybe I'm just like skipping over it, is any reference to this is like extreme or excessive or unusual in his experience.
Well, that was a fact finding the district court made in its order, and I
Okay,
don't
but
think
based on
nervous or
what?
extreme nervousness.
But based on what is what I'm trying to get to, right? So like, is the argument that it's based on this line, that his answering was clunky and deliberate, that you think from that testimony you can conclude that that was excessive or extreme nervousness? Or what is the other factual basis that supports the finding that it was excessive or extreme nervousness?
We also have his police report, which I know we've discussed. There are some concerns about that, but at JA 403, Tilford wrote the defendant, quote, was extremely nervous during the interview. And I don't believe that nervous or extreme or excessive nervousness is a magic word, right? The district court is making a fact finding based on the description of the defendant's behavior. In any event, of course, we agree with you, Judge Richardson, that any error in admitting the 5 kilos seized during that traffic stop was harmless, given the overwhelming evidence that was introduced at trial.
Do you really argue that it was harmless on the conspiracy conviction, or do you primarily argue that it's harmless on the PWID convictions?
It was harmless as to all 3 convictions, Your Honor. I see my time has expired.
All right.
Unless-
Judge Traxler, do you have any questions?
I do, Judge Wynn, if you would indulge me just a second. This is a question mostly of personal curiosity. It has to do with the November stop of the defendant by Trooper Miller in November.
Yes, Your Honor.
After Trooper Miller had finished with all the things he had to do with regard to the stop, the defendant was in his car, Trooper's car. I believe he was handcuffed, and then he was taken over to meet with a DEA agent. My question is, after the trooper had finished with him, after the purpose of the stop had been completed, and when he was being transported in handcuffs, what's his custody status at that point? Specifically, is he under arrest?
Your Honor, my understanding of the record is that he was in custody. I don't know if he was not formally arrested, but he was in custody.
Then on what basis was he in custody?
Based on Miller's collective knowledge of the probable cause that Smith had that the defendant was engaged in drug trafficking.
So he's in custody, but he's not under arrest.
Right.
Okay, thank you. Thank you, Judge Wynn.
Judge Richardson. Thank you very much. We'll hear from the appellant. You have just a few minutes.
Thank you, Your Honor. To address a number of the issues that were raised with my colleague, Mr. Smart identified at the hearing on the Speedy Trial Act his attack of the continuance from October of 2019. There was a colloquy that I cited in my reply brief that discusses that, raising that. So there was no waiver by Mr. Smart.
I'm sorry, I want to make sure I understand that. Your claim is that in the handwritten motion that he submitted, he properly raised the Speedy Trial Act violation with respect to that continuance.
In his handwritten motion, Your Honor, he recites the course of events in his prosecution.
And then makes a Sixth Amendment argument under the Baker factors that doesn't mention that at all. He gives a factual summary of everything that's happened. And then he makes a Sixth Amendment argument unrelated to that continuance.
Agreed. And at the hearing, he and Judge Novak have a colloquy about the October continuance of the December trial date. And when you look at Henry and you look at Velasquez, you look at all the cases from this circuit, it never says there's got to be a specific identification of a particular period. The statute doesn't say so. The statute simply says it has to be a written motion. And the Sixth Circuit in Greece.
Right, but the basic principles of waiver that we have is that you don't get to say, I have a Fourth Amendment violation without identifying which of the traffic stops that you think is a violation, right? You don't get to say there's a Speedy Trial Act violation and not identify what conduct you think violated it, right? So it's not about the statute, it's just our basic issue preservation rule. And that's he did not preserve that issue. Now, you might have an argument that the judge addressed it anyway, and that's a separate story. But I want to make sure I understand. How is it that he made that argument?
His motion to dismiss was based not only on the Sixth Amendment, but also on the Speedy Trial Act. And when he was at the hearing, he contemporaneously at that hearing raised this very issue and had a colloquy with the judge about it. So the way I look at it, Your Honor, is the act does not require specificity in the written motion. It requires a written motion, which Mr. Smart did without dispute. Were the grounds of his challenge, the Speedy Trial Act, presented to the district court? They were at the oral argument on the motion. And I believe that under this court's case law and under the statute, and when you look at Zedner and its very dim view of waiver in Zedner, I believe that was sufficient. I want to address the harmlessness issue from the Louisiana traffic stop. It's important to recognize that the only physical narcotics against Mr. Smart at trial were the 5 odd kilos from Louisiana, 27 grams from Newport News in August of 2018, and the little less than 27 or just over 27 grams from the Pittman controlled buy. If you're painting someone as a interstate drug dealer and the drugs that the government's putting on the table in front of the jury consist of 5 kilos from an illegal stop, search, and seizure compared to 2 less than 1 ounce quantities.
It's totally fair for the conspiracy count, but help me understand how that affects the 2 PWID counts, right? So that argument is about the conspiracy count, and I understand that one. What I don't understand is how it affects the 2 PWID counts, right? I mean, the jury's instructed you got to consider each count separately. Those counts are not about being some broad interstate drug dealer, right? They're about these 2 PWIDs.
Well, if you look at the August 2018 Newport News stop, again, it's a possession level quantity of cocaine, less than 1 ounce. Why does that become possession with intent to distribute? It becomes possession with intent to distribute
Because he sold that same amount. For him, it's not like consumption quantity, right? It's like the amount he sold in May. And we got a pretty good idea that he's sells that kind of quantity. In fact, we got a pretty good idea people sell much smaller quantities than a full ounce, right?
Your Honor, but I understand. My time has expired. May I conclude?
Please.
If you look at May, though, Your Honor, he didn't sell it. Jones sold it to Pittman, right? So he's put into that because why in Louisiana in 2017 he was caught with 5 kilos. Thank you very much.
Thank you. Thank you both. Court has reinstituted its policy of coming down in addition of greeting counsel. Judge Traxler will be with us
In spirit.
in spirit. Which side are you representing?
We're representing the appellant.
I asked the clerk if would you check to see if the counsel for the appellee is here. We will proceed now with the appellant's counsel for the day. That is a necessary part of this particular proceeding, particularly for you. Now, okay, we're glad to have you here with us here. We will proceed with hearing from the appellant and the side.
May it please the court, Lawrence Rosenberg. I would like to introduce my student, Devin Redding, who is a third-year student at the West Virginia University College of Law and our Supreme Court Litigation Clinic. She is a qualified law student and will be presenting argument today.
All right, we look forward to hearing your argument.
Good morning, Your Honors. May it please the court. This court should reverse the district court's decision and hold that Mr. Mays' Fifth Amendment due process and equal protection claims are cognizable under Bivens. Mr. Mays' claims do not present a new context and fall squarely within prior Bivens precedent. But even if Mr. Mays' claims do present a new context, there are no special factors counseling this court's hesitation in extending a Bivens remedy in this case, and no reason to think that Congress would want to withhold a remedy in this case. Moving first to Mr. Mays' equal protection claims. These claims are not meaningfully different from the claims recognized in Davis v. Passman, where the court recognized that the Fifth Amendment confers on an individual the constitutional right to be free from illegal discrimination. Although gender discrimination was at issue in Davis, the court recognized that individuals are protected against all types of illegal discrimination.
Speak to the reality of where the Supreme Court is on Bivens claims. There are directions in which you, even as you're going now, even if we were to agree with you, there are some restraints that we're operating under, not only from the Supreme Court, but from this court in terms of how we deal with Bivens case. And you correctly point out that there's a Fifth Amendment-based Bivens claim from Davis that we can look upon, but then you also did notice, bring forth quite candidly, that that's a different situation. There's one for procedural due process and the other's for race discrimination. So, I mean, I don't want to make it just an academic proceeding, but I think we have to deal with where we are on Bivens and what the Supreme Court is, I think, somewhat unusually been rather forthright in terms of what it thinks of as precedent in this case. And deal with that and how you think we can get around what the Supreme Court seems to be very clear, about as clear as you can be, even if it's dicta or advisory or whatever, it's signaled this thing pretty clear to us. Talk to us about it.
Yes, Your Honor. So Davis v. Passman was one of the 3 cases that the Supreme Court recognized a judicial remedy, a judicially created remedy under Bivens. That case is factually analogous and legally analogous to the claims Mr. Mays raises about equal protection. As you mentioned, Your Honor, his due process claims could present this court with a new context. In that case, the Supreme Court directs courts to look at special factors and go through the Abbasi special factor analysis. Importantly, recent Bivens decisions such as Egbert v. Boole, Ziegler v. Abbasi, and Hernandez v. Mesa all implicated large-scale executive policy, which is not at issue here. Mr. Mays' challenging individual instances of constitutional deprivations. He is not challenging large-scale executive policy, as we have seen in recent.
I thought Egbert sort of told us that that's the wrong level of granularity, right? That, you know, in Egbert, we got to look at sort of border security writ large, right? We're not looking at this one particular incident. We got to look at sort of the impact on border security. And, you know, border security is important, but, you know, we also house a lot of inmates, right? And so why wouldn't we look at, you know, General Bureau of Prisons effectiveness, just like we look at border security effectiveness in a similar way?
Well, Your Honor, I believe when the court looks at Mr. Mays' specific claims and considers the potential burden on prisons and the prison administration system, the court will find that there's no undue burden on prisons or prison administration. Going back to the Egbert point, Your Honor, Mr. Mays' claims do not implicate large-scale policy. They challenge
the Bureau of Prisons is a pretty large-scale program, right? I mean, I don't know how many, but there are lots and lots of people in federal prison. There are lots and lots of people who work as federal prison guards. Maybe not as many as border security, but it's in the same order of magnitude. So why am I thinking about the Bureau of Prisons fundamentally different than Border Patrol?
Yes, Your Honor. So in Abbasi, the court took special care to recognize that Fifth Amendment claims, like Mr. Mays, do not impact the adoption or execution of prison administration policies. So there would be no undue burden on the prison system.
But wasn't that Egbert too, right? Like the particular claim in Egbert wouldn't have like limited policies or procedures, would it?
Well, Your Honor, I believe the particular claim in Egbert in reference to the Fourth Amendment claim, the court considered how recognizing that claim would impact border security's unique operational mission in terms of national security implications. Here, again, we don't have any large-scale policy implications. And these are, in fact, the exact type of claims that the court in Abbasi recognized are most efficiently addressed by way of a judicially created remedy. In reference to Mr. Mays' equal protection claims, these aren't claims that are unique to the prison system. These claims mirror the claims in Davis, and those claims arise from a typical workplace interaction and a typical supervisor-employee relationship. That Mr. Mays' supervisor and employee relationship and that his workplace was inside of a prison is not a meaningful difference. Mr. Mays was the lead mechanic and he received training on relevant equipment to work in the Unicore optics factory. The allegations of discrimination by his Unicore supervisor are that he was withheld information and withheld necessary tools needed for Mr. Mays to perform his job.
So the uphill battle that I was referring to, and that's why I say we could engage in an academic discussion, but the reality is what it is. There have been 3 Bivens cases that the Supreme Court has decided. And since, I guess, the last 12 years, 12 times or so, the court has not done anything to expand that. It sort of shut the door on that. And the court's been pretty explicit. It says, you know, if there's a basis for expanding Bivens, then they look to see if there's any rational reason, I mean, going out of the way to say it, that Congress would be better suited to weigh on this than the courts. So tell me, can you think of even one reason why the Congress here would be, as opposed to the court, should be the one to authorize these type of damages as opposed to the court?
Well, frankly, Your Honor, as I mentioned before, again, Mr. Mays is challenging individual instances of constitutional deprivations. The court has recognized that these types of challenges are difficult to address except by way of damages actions after the fact. And courts routinely engage with these type of inmate claims, and they routinely engage with the rights of prisoners and determine standards for the treatment of inmates in the BOP system.
I just want to make sure I understand that. Why is the argument you're making that it would be hard for Congress to fashion such a remedy? I mean,
No, Your Honor.
it's sort of done it in other contexts, right? Like 1983 sort of seems to come to mind, right? Like they seem to be able to do it at least in other contexts. Why wouldn't we think so here?
Well, Your Honor, I'm not suggesting that it would be difficult for Congress to fashion a remedy in this case. I'm merely suggesting that congressional silence may be important in this case. So the fact that a congressionally created remedy for Bivens type claims has never occurred, but yet Congress was able to pass the Federal Tort Claims Act, which switched the liability and gave plaintiffs an opportunity to hold the government directly liable in order to replace individual liability. So Congress's silence on Bivens may mean that they endorse a judicially created remedy for individual liability.
Would that argument apply to each of the claims that the Supreme Court has rejected Bivens on the last 12? I mean, that argument I get the argument, right? I'm not even saying it's a bad argument. I'm just saying it would similarly apply, would it not, to all of the previous 12 attempts the Supreme Court has shot down, right?
If I'm understanding your question correctly, Your Honor, I think that, yes, Congress has had an opportunity to create a legislative remedy or a remedy by statute. My
point being is that, like, if you rely on legislative silence, right? Wouldn't Egbert come out different? Wouldn't Abbasi come out different? Right? If legislative silence was enough to give the two of us or the three of us that authority, then we would have had that authority in Egbert and Abbasi, and I could go on with the list, right?
Your Honor, I think critically with Egbert and Abbasi and even Hernandez Mesa, it was really the special analysis and those unique national security considerations. As I mentioned before in Egbert, particularly with reference to the Fourth Amendment claims, it was really looking at the Border Patrol's unique mission and understanding the interplay with border security and national security. So I really think in those cases, which really challenge large-scale executive policy, they're fundamentally different from the claims Mr. May is raising here.
Well, take for instance the Prison Litigation Reform Act. Congress enacted that after those 3 cases, but it did not make a provision for damages. What do you make of that?
Well, Your Honor, the PLRA does not foreclose inmate claims for monetary damages. It merely regulates them. It requires that inmates must exhaust all administrative remedies before seeking monetary damages and bringing suit in federal court. And I think in that sense, the PLRA is complementary. It's not exclusionary. The legislative history of the PLRA also bears this out. It shows that Congress specifically amended the PLRA after the court's decision in McCarthy v. Madigan to remove judicial discretion on what constitutes a minimal acceptable standards for administrative exhaustion. They codified administrative exhaustion requirements, but that codification did not foreclose inmates from bringing civil rights claims or claims for monetary damages. And I think if we look at when the PLRA was enacted, noting that it was enacted against the backdrop of Bivens, we can infer that Congress assumed that a Bivens remedy would be available to inmates. Your Honors, if you don't have any further questions, I will move to Mr. Mays' due process claims. Again, Mr. Mays' due process claims are not meaningfully different from those recognized in other cases.
How are you going to go there with our case in Bolger?
Yes, Your Honor. So in Bolger, this court did reject Bistrian v. Levi, which is the court we briefed our reliance on. However, that's an Eighth Amendment failure to protect claim, which is fundamentally different from the Fifth Amendment due process claims that were put forth in Bistrian and put forth by Mr. Mays. I think particularly important is that this also reflects Abbasi's reasoning that one of the reasons to find a new context is a different constitutional right, or the implication of a different constitutional right. And here the court did just that. So I think it's particularly distinguished because it's been Bolger v. Horowitz is an Eighth Amendment failure to protect claim. I also believe that Bolger reflects this court's reasoning in Bivens cases, where it adopts a case-by-case approach to assess the viability of Bivens remedies for federal prisoners. And it also emphasizes Abbasi's conclusion that if this court should find a new context, they can conduct a special factors analysis. And as I mentioned before, Your Honor, under this Abbasi framework, there is no reason to withhold a remedy here or to think that Congress would want to withhold a remedy in terms of Mr. Mays' challenges to individual instances of conduct and individual instances of constitutional deprivations.
All right. Is anything further?
Nothing, Your Honor, unless you have any questions.
Judge Traxler?
No, thank you.
All right. You have a few minutes in rebuttal reserve.
Thank you.
We will hear from the appellee in this matter.
Good morning, Your Honors. Assistant United States Attorney Sharon Wilson. I am here to introduce to the court, and we thank you so much for hearing from our students, Marie Sapita Mikaj. She is one paper away from graduating from Duke. It's due on Friday. So we're so excited. Your Honors, and may it please the court, my name is Marie Sapita Mikaj, representing appellees. Your Honors, as you pointed out in its recent decision in Egbert, the Supreme Court emphasized that courts should decline to extend Bivens if there's any reason to think that Congress is better equipped to create a damages remedy in that case. Therefore, this court should affirm the ruling below and decline to extend Bivens for two reasons. First, appellants' claims arise in a new context from the existing Bivens contexts. And second, important special factors counsel have hesitation in expanding Bivens to this case, including those that the court found significant in declining to extend Bivens in Bolger, such as the existence of an alternative remedial scheme and congressional intent to limit court interference into the prison context.
Can you help me understand the line in Egbert that it is any reason to think that Congress would be better than the courts? And yet, so that seems to be like a pretty easy standard. But the court then says that you have to do it in each case, right? Where I think we could probably say that there's always a reason to think that Congress is better than we are at most everything, right? So like, why is the court telling us to do this individual analysis at the same time setting up a test that is plainly going to be met in every single case?
Your Honor, I'm not sure the reasoning behind that test, but the Supreme Court in Egbert did note that in almost every situation, the answer to that question will be yes. So while respecting the existing precedent, the court is limiting those cases almost to basically their facts in future cases. And here, the context of this case is just fundamentally different from that which occurred in Davis. Here, the court.
Can you talk about why it's fundamentally different? I mean, we tend to think about, if anything, our Constitution being more protective of race-based claims than of gender-based claims. Think about the tiers of scrutiny that we apply. So help me understand that.
Yes, Your Honor. So the difference between race discrimination and gender discrimination isn't the only difference in this case. For example, in addition, this took place in the prison context, which is fundamentally different from just your typical day-to-day employment context. Prison officials have to make many discretionary decisions in inmate work assignments from, for example, deciding whether it's a safety and security threat to give someone a particular tool or particular information.
What was the work context of Davis?
That in that case, the congressman fired his secretary for being a woman.
Right, and we think about Congress having sort of special concerns too, right? Both about safety and security, right? We have issues that we've, repeatedly hear about, right? The safety and security of government officials, right? And so, I mean, yes, they're a little bit different, but it's not like this is in the, the McDonald's setting or some non-secure facility. We are often concerned with Congress and its security, right? Just like we might be concerned about prisons and the security there. Why is that meaningfully different?
Your Honor, even in Egbert, the court noted that Davis went under a different type of analysis than the court uses today. So it didn't really consider those special factors in its analysis, whether there might be particular concerns that.
Right, but I think what I'm really asking is like, why is this really a different case, right? In other words, you might say that the greater includes the lesser, right? If we're going to protect gender discrimination in a context where security is paramount, and I assume you're not arguing that security in Congress isn't paramount.
No.
Right. So then it seems like to me that's the greater, that if we're going to protect that, then obviously we would similarly protect race-based claims in a prison context where security is paramount, right? Why isn't that the analysis at the step one of whether this is the same context, is that the greater includes the lesser?
Your Honor, the Supreme Court has made it very clear that even in very parallel circumstances, we're still to look to whether special factors counsel hesitation. And here, the situation is not even exactly parallel. Beyond the employment context, Mr. Mays is also alleging violations related to his placement in administrative detention, his transfer to a different facility. And these claims taking place in a prison context where every single decision that an official makes, even, for example, whether to give someone a paperclip, could be used as a weapon potentially in prison in a way that I think you typically wouldn't think of in the congressional setting. So that is the security context that they are facing and that the officials are making decisions in is just fundamentally different than in the congressional employment setting.
Can you talk a little bit about the alternative remedial scheme? So if we got to the special factors, why you think there's an alternative remedial scheme that was available here?
Yes, Your Honor. In the prison context, prisoners who are facing similar conditions of confinement claims to Mr. Mays have multiple administrative remedies available to them. First, the BOP has the administrative remedy program, which both this court in Bolger and the Supreme Court in Malesko found relevant to determining that they should.
Does that extend to these employment-based claims? I get the non-employment-based employment, maybe we have to put that in quotes, but let's call that the employment claim. But do those remedies extend to the employment context? So is that an available remedy if you say, I've been racially discriminated against in the shifts that I'm getting in the prison workshop?
Yes, Your Honor. There are policies governing inmate work assignments, and that is a type of claim that an inmate can bring grievances about through the administrative remedy program. And in addition to the administrative remedy program, other remedies could be available to an inmate who is in Mr. Mays' situation, including suing for injunctive relief, mandamus relief, or declaratory relief. And again, the existence of these alternative remedial schemes was sufficient in Bolger to conclude that that was a special factor that warranted declining to extend Bivens, because the court could conclude that Congress and the executive branch are better equipped to determine whether those remedies are sufficient in this case.
And does the remedial scheme include as well retaliatory claims? So in other words, it seems easily to, or at least arguably to include the substantive discrimination. But is there a provision in the remedial scheme, the prison grievance system, for retaliatory claims? So in other words, for making the claim itself, retaliation for making the original grievance itself?
Your Honor, I am not sure whether the policies governing it say anything about retaliation specifically, but I do believe that inmates are able to bring those claims through the administrative remedy program.
Are there examples? I mean, that's what when I look at the policies, they don't seem to like address retaliation. Why should we think the retaliation is included? I understand, other than just you thinking it.
Your Honor, I'm not sure of the answer to that question. I apologize.
When we look at the three cases, the legal case, Fernandez and Gilbert cases, those are cases that dealt with what appears to be sensitive context of national security or border type cases. And so when we look at that from a restrictive analysis, is why wouldn't these claims pass muster? I mean, the Supreme Court has indicated that, when you have that context there, you can proceed.
Sorry, Your Honor. You're saying when you don't have the sensitive national security context, you can proceed? You
had the three cases in which those issues were troubling to the court, but those issues are not here. So why is it this particular one would be one that would trouble the court also? We're not dealing with national security, military, or immigration concerns.
Your Honor, there are also significant concerns regarding security and safety in the prison context, and those concerns raise many discretionary decisions that officials have to engage in on a day-to-day basis, similar to in those other contexts. The Supreme Court has been concerned about the court intruding into kind of these day-to-day discretionary decisions that could have system-wide implications. And if the courts are to look at every determination in a prison of whether to give an inmate a particular tool or whether to place an inmate in one work assignment versus another work assignment, this will involve a significant level of judicial interference into an area that Congress has expressed an intent to limit.
What if we view this that Mays is not asking to have imposed a systematic liability against these officials, that instead is similar to what was done in Ziegler, an individual circumstance of law enforcement type abuse or approach to this? Does that change the analysis? The fact that it is not seeking a systematic type liability?
No, Your Honor, it doesn't change the circumstances here. Ultimately, the fundamental question is whether there are reasons to think that we should defer to Congress on whether a damages remedy is appropriate within a particular system. So here, for many of the reasons already discussed, there are reasons to think that Congress would be better equipped. And the fact that Mr. Mays didn't get a remedy in this particular case doesn't necessarily mean that a judicially created remedy is appropriate, as the Supreme Court has noted in Egbert, and also in Schweiger. Instead, the question is really, as this court said in Bolger, the question is really whether, looking at this elaborate remedial scheme, should the court augment it by creating a judicially created remedy? And Egbert has said that in almost every case, the answer to that question is no. And continuing on the separation of powers concerns that are in this case, here, as Your Honors already mentioned, Congress has legislated frequently and intensely in this area, including through the PLRA, but they've never authorized an individual damages action for inmates. And contrary to what the appellant argues, that that congressional silence can be read to allow for such a remedy, Supreme Court precedent has shown that we don't read from congressional silence an intent to create a remedy, but rather the opposite, that the court should then defer to Congress on the question of whether or not to augment that remedial scheme that exists. And similarly, as I mentioned earlier, a case like this threatens significant intrusion into sensitive and discretionary executive branch functions. The case law on this matter is clear. The Supreme Court in Turner said that running prisons is particularly within the purview of the executive and legislative branches. And Congress, through the PLRA, sought to limit both prisoner litigation and court oversight of the day-to-day operations of prisons. In addition, Congress has delegated significant authority to the BOP over prison life and has given BOP a lot of discretion over the particulars of how prisons are run. Therefore, this court should defer to Congress on whether a damages remedy would helpfully augment that system and create additional deterrence against these types of violations that Mr. Mays has alleged. If Your Honors have no other questions, may I briefly conclude? Great.
Yes.
Your Honors, this case represents a fundamentally different context from any of the existing 3 Bivens contexts, including Davis, and special factors such as the existence of an alternative remedial scheme and separation of powers concerns suggest that the court should defer to Congress on whether a damages remedy is appropriate in this situation. Therefore, we ask that the court affirm the lower court's ruling and decline to extend Bivens in this case. Thank you.
Judge Traxler, do you have any questions?
No, thank you.
Thank you, Ms. Redding. We'll hear from, Ms. Mikosh. Is that right? We'll hear from you, Ms. Redding.
Thank you, Your Honor. I have 3 points on rebuttal. First, with reference to Mr. Mays's equal protection claim, I want to emphasize that this is not a new context and it does not implicate any special factors analysis. It is factually and legally analogous to Davis v. Passman. Again, Mr. Mays's individual claims of discrimination arise in a traditional workplace context. The Unicorn Optics Factory, where he worked, is a traditional workplace. It's just inside the walls of a prison. But importantly, one of the reasons that it does not implicate large-scale prison administration or prisoner security, institutional security concerns is that the Unicorn Optics Factory operates like a traditional factory. Mr. Hoskins, who is Mr. Mays's first-line supervisor, is not a corrections officer. And while he may have some input into the inmate administrative process or the inmate discipline process, he does not wholesale own any part of the prison administration process. In terms of Mr. Mays's equal protection claims, there's no need for this court to get to a special factors analysis. Again, he is alleging racial discrimination, which falls under the same umbrella of illegal discrimination that the court recognized in Davis v. Passman. And the court brought up the scrutiny applied to each of those types of discrimination. At bottom, racial discrimination is illegal discrimination. And as the court noted, it receives a higher level of scrutiny, indicating that it is of the same type of discrimination that was recognized in Davis.
Why
Mr.
doesn't
Mason,
that actually cut the other way, right? Because we're asking simply whether it's different, right? And yeah, it's higher, but it's different, right? So, I mean, it's in the scrutiny case at some level, but doesn't that suggest to us actually that there is a difference?
Your Honor, the racial discrimination Mr. Mays alleges is not meaningfully different from the discrimination raised by the plaintiff in Davis, and that is the key. It needs to be meaningfully different in order for a court to find a new context. Importantly, the court invoked Bowling v. Sharp in their holding in Davis v. Passman, which was a racial discrimination case. So this indicates, again, that Mr. Mays's racial discrimination claims are of the same type as the gender discrimination claims raised by the plaintiff in Davis. And it also just outlines the contours of equal protection claims recognized in that case. Again, the umbrella of illegal discrimination that the court was contemplating, which Mr. Mays's claims of racial discrimination fall squarely within. My next point, Your Honor, I want to talk a little bit about administrative remedies. The idea that Mr. Mays could motion for an injunction or for any sort of other remedy is not practical. He was in administrative confinement without counsel. Practically speaking, it was impossible for him to enjoin the constitutional deprivations and those actors who were depriving him of his constitutional right from administrative detention. Additionally, going through an administrative process, which Mr. Mays did, and he did fully exhaust the administrative remedy process, he would be bringing the claims to the same individuals who retaliated against him. For Mr. Mays, like the plaintiff in Davis, there is no other remedy. It is damages or nothing. Your Honor, I see that I have exceeded my time. So if you have no further questions.
Thank you very much.
Thank you.
Court will acknowledge Professor Rosenberg, fine job that you have done bringing a student to us. You were court appointed, and we appreciate the fine argument for you, Ms. Redding. The court could not do what it does without court appointed counsel. I should have mentioned in the early case that Mr. Thea was also court appointed, and the court is very appreciative of court appointed services to help us get our work done here. Likewise, Ms. Wilson, as a supervisory attorney there at the AUSA, you brought a fine student to us, who both students presented, we believe, excellent arguments. I think Judge Richardson and Judge Traxler would agree with me that our legal profession appears to be in good hands for the future, if this is the caliber of lawyer you're going to be sending us. So thank you both. Judge Traxler, did you have anything further to ask before we proceed to greet the counsel?
No, Judge Wynn, thank you.
We will come down, greet counsel, and proceed to the last case.
May it please the court. My name is Tommy Strelka, and I am here today to represent the appellant in this matter, Mr. John Massey. This is a case that asks this court if a plaintiff timely files a Rehabilitation Act claim in state court and then takes a statutory voluntary non-suit, may that plaintiff then file his or her claim in federal court in the time frame provided by that statute. The state statute is Virginia Code 8.01-380. The trial court, the lower court in the Western District of Virginia, answered that question as no, and dismissed this matter on a motion to dismiss filed by Virginia Tech. The merits of the case are not at issue. The issue of equitable tolling is not at issue. Rather, the issue of statutory tolling is at issue. Mr. Massey did file his lawsuit timely under the Rehabilitation Act's statute of limitations, which isn't provided within the federal statute. Like some other federal statutes, such as 42 USC 1983, it is a federal statute that borrows a state statute of limitations. Because Virginia has enacted a analogous disability discrimination law that has a 1-year statute of limitations, that applies to the Rehabilitation Act. Mr. Massey timely filed within a year. He then timely and followed all of the requirements to initiate notice of a voluntary non-suit. Whether or not he followed the statutory requirements of that non-suit are not disputed. The state court issued a non-suit dismissing the matter without prejudice. It was his first non-suit, as it was his right to do that.
Speak to Virginia court precedent.
Yes, Your Honor.
And their manner of handling this, particularly the question on subject matter jurisdiction.
Your Honor, I'm sorry.
Speak to the Virginia cases here and the implications insofar as do they not imply that this is a subject matter jurisdiction type issue?
Right, Your Honor. Well, so where it seems to come down to in following the analysis here is whether or not there was exclusive jurisdiction under the Rehab Act to file in federal court. There's a presumption that there's concurrent jurisdiction in state and federal courts from the U.S. Supreme Court. There have been a host we've cited of other cases that have other federal cases that have found there to be concurrent jurisdictions, a concurrent jurisdiction for the Rehab Act case. The U.S. Supreme Court has never found it.
Is this, I'm trying to understand the argument in the context that Judge Wynn asked the question. You're arguing that the Virginia court had subject matter jurisdiction because sovereign immunity did not apply.
Yes, sovereign immunity, Your Honor, is a defense that addresses the merits of the case. And to look at Supreme Court of Virginia.
Those are two different points, right? So one point is you're saying there is no sovereign immunity. And then the second point I understand you'd be making is that sovereign immunity is just a defense to adjudication on the merits.
Yes, it's what's known as active jurisdiction.
Right. But you're also making the first one. You think the Virginia court had jurisdiction, whatever you want to describe it, in order to adjudicate the merits of the case.
Your Honor, the state, first off, the issue of whether the state court had, whether or not whether sovereign immunity applied to address the issues of the case was never addressed by the state court.
I understand that, but we're trying to ask the question of whether the court had jurisdiction.
Correct.
Right. And if it did not, the effect of that.
Right. And
are you both arguing that sovereign immunity did not apply at all? Are you making that argument?
No, Your Honor.
Okay.
The argument that we were making is that a sovereign immunity defense truly attacks the merits of the case and particularly prevents the merits of the case from being aired in front of the court. Rather.
It's not subject matter jurisdiction.
Correct. And so therefore, the non-suit statute was clearly enacted for a situation such as this, in which a litigant has filed in a court without exclusive federal jurisdiction. There is no provision within the Rehab Act that says that the litigant must file in federal court. And the litigant has a statutory right under Virginia law to a non-suit as long as they follow the requirements of that, which he did.
Doesn't it require, it requires an order by the court, right? You don't get a non-suit without an order by the court.
Correct. You have to.
And the court has to have, at least it seems to me, after McNamara and Waterman and the like, the court has to have subject matter jurisdiction to issue that order. Might not have to have personal jurisdiction. And I'm not sure why that makes sense, but that seems to be what the court says. But it's got to have subject matter jurisdiction in order to issue that decision, to grant the non-suit, right? I mean, that's what Waterman and McNamara tell us.
Right. Well,
do you agree with that premise?
I agree with that premise.
Okay. And so tell me why, let me ask a different premise. You also agree that the court in Asphalt says sovereign immunity is subject matter jurisdiction.
Yeah, I agree with what.
Okay.
That.
So help me understand how those two don't inevitably lead to the conclusion that you lose.
Your Honor, because first off, the lower court did enter an order for the non-suit, and that order was not contested. That order was not appealed by at the state court.
But Singh tells us it's void ab initio, right? So if it, that's Virginia courts say if you lack jurisdiction, it's void ab initio, right? So it's not voidable, it's void ab initio. So it's like it never happened. Like that's what Singh tells us.
Right. Your Honor. But I have to, plaintiff contends, what Massey contends, Your Honor, is that there has not been a court that has found that the Rehab Act has exclusive jurisdiction for federal court, that a court that when it was filed, that the state court clearly lacked jurisdiction. That's what Schofer says. And that's one of the cases that the district court relied on in adjudicating this.
So why does it matter whether it was clear or not, right? If the state trial court lacked jurisdiction, subject matter jurisdiction, maybe not personal, but at least subject matter jurisdiction, then Virginia courts have told us they lack the authority to issue a non-suit order. And Singh tells us that any such order is void ab initio, right? It's like it never happened, which means for us, it's like it never happened. And so it does not toll your statute. I'm just having a hard time understanding which piece of that link is where you think your argument lies, right?
Right. Well, again, Your Honor, my response to that is that order was entered and never contested at the trial court. And then this issue of jurisdiction and this about that court's jurisdiction, not the federal court, but the issue of that court, the state court's jurisdiction.
We are clear that we're talking about subject matter jurisdiction.
Right. Correct, Your Honor. But my point is that.
So what does it matter if you object or not object or bring it up? What difference that makes?
There's an argument that from the trial court and from the appellee that the plaintiff waived these arguments.
You can waive subject matter jurisdiction?
No, the appellee indicated that the appellant and the court agreed that the appellant waived the argument as to the jurisdiction. The only argument that was advanced in the in the motion for dismissal by the appellee in this case initially was whether or not he had timely filed his Rehab Act claim, not whether there was jurisdiction, not whether anything was exclusive, subject matter jurisdiction. These arguments weren't included in the motion to dismiss.
Do they have to be if the court lacks subject matter jurisdiction? It appears on the face. Do they have to make that argument?
Well, this is an argument that the appellee raised in their motions and briefing, Your Honor, and the plaintiff contends that it is irrelevant to the facts at hand. But in any event, we get to the hearing in the court, and this did come up, the jurisdiction of the matter. It's the plaintiff's contention that the non-suit statute was enacted by the General Assembly for cases in which a plaintiff may have filed a matter of non-exclusive federal jurisdiction in state court and may, if it's their first one and they meet the statutory requirements, issue that notice of a non-suit, which is their right, and the court then entered that order. That order was not appealed or contested, and then it was a timely filing in federal court. The chauffeur cases, the chauffeur case as
So just so I understand, so I mean that might be like a plausible reading of the non-suit statute, but except the challenge that we've got, right, is that doesn't so if they intended it to do all that, great, but the Virginia Supreme Court has told us if you lack subject matter jurisdiction, you can't issue such an order, right? And then Asphalt, I'm not trying to beat a dead horse, right? But like, an Asphalt tells us the subject matter jurisdiction. And so I'm just having trouble understanding where in that chain is your rub.
Yeah, Your Honor. Well, our response is that the state courts are courts of general jurisdiction, and that the matter was, the non-suit order was entered, it wasn't contested, and everything was timely filed. And you know, our briefing has highlighted numerous cases in which there's been concurrent jurisdiction for Rehab Act cases within the state and federal courts, and that this type of situation has been contemplated. Your Honor, if I'd like to mention some other arguments here. The appellee has mentioned, I mentioned the chauffeur case. That's an ERISA case. That is in a case of clear exclusive jurisdiction in which you must file within federal court. They've also highlighted the Woodson case. The Woodson case is a case that arises under the National Flood Insurance Act, which also has exclusive jurisdiction. There's never been a case in which the U.S. Supreme Court or a federal court has indicated that the Rehab Act has exclusive jurisdiction to federal court. The chauffeur court itself acknowledged that when a state statute of limitation applies, a court must also apply state principles of tolling those limitations. As to apply that reasoning here, the tolling, the statutory tolling would apply. The U.S. Supreme Courts has said that litigants have frequently had the right to take benefits of state tolling statutes in cases arising under other federal statutes, such as 42 U.S.C. 1983, a federal statute with a state statute of limitations. And again, sovereign immunity may divest the state court of what is known as active jurisdiction, but not potential jurisdiction. And this means that sovereign immunity would theoretically prevent a court from hearing the merits, but it has no bearing on whether a court may enter a non-suit. And that is our argument. Thank you.
Thank you.
Do you have any questions? Thank you.
All right, we'll hear from the appellee in this case. Before you proceed, I neglected. Judge Traxler, did you have any questions?
No, Judge Wynn, thank you.
Thank you. You may proceed.
Good morning, Your Honors. May it please the Court, Annie Chang, Assistant Solicitor General to the Commonwealth of Virginia on behalf of Appellee Virginia Tech. With me at council table is Erica Maley, Principal Deputy Solicitor General. Parties agree that Appellant Massey filed his federal claims in federal court outside of the 1-year statute of limitations. Those claims are thus untimely unless they're told. The only question before this court is whether Massey's claims were told due to the state court's non-suit order of Virginia equivalent to a Rule 41A voluntary dismissal. This court should hold that those claims were not told due to the state court's non-suit order because that state court had no subject matter jurisdiction. And here's why. Massey has conceded in his briefs and in oral argument at this point that Virginia Tech had sovereign immunity in the state court proceedings. As Judge Richardson has noted, the Supreme Court of Virginia in Afzal versus Commonwealth has squarely held that where sovereign immunity applies, that court has no subject matter jurisdiction.
So can I stop you there? Because I did say it earlier, but not so sure that that's right. And so I want you to help me a little bit because as recently as 2022, the Virginia Supreme Court in Farmer, and then relying on its earlier case in Teachy, held open the question of whether sovereign immunity is a question of subject matter jurisdiction or personal jurisdiction. Right? It says we need not decide that question here. And the Virginia Court of Appeals, including, I think, Data General and Marian Indian Tribe, holds the opposite, right? It says, given the Supreme Court's not deciding it, quote, sovereign immunity presents a question of personal jurisdiction rather than subject matter jurisdiction. And so I'm in a little bit of a hard spot, right? Because I've got the Virginia Supreme Court, maybe in dicta in Asphalt, saying it's subject matter jurisdiction, but I've got the Virginia Courts of Appeals who are persuasive, not binding, obviously, but persuasive, telling me, no, the Virginia Supreme Court hasn't answered this question, and instead we've answered it in calling it personal jurisdiction. Help me understand how I square those two ideas.
Your Honor, I would say, first of all, as you've pointed out, the Court of Appeals in Virginia is not binding, and we would contend actually that that is a holding in AFSL, that sovereign immunity deprives the court of subject matter jurisdiction. And I recognize that some law,
but it's only limited. Asphalt only says that it's subject matter jurisdiction, meaning it's non-waivable, right? And so it's subject matter jurisdiction, so that it can be raised at this point. Doesn't necessarily mean it's subject matter jurisdiction in the way that we might think of it in a federal court setting.
Sure, but the Supreme Court of Virginia in McManama has also held that you need subject matter jurisdiction for the non-suit order to have the collateral effect of tolling. And I think
so that's totally true. The question is whether sovereign immunity is one of those types of orders or not.
Mm-hmm. And I think that AFSL, we look at AFSL versus Commonwealth to say that sovereign immunity is, and I would contend that because sovereign immunity in the state of Virginia is not waivable except for parties can raise it for the first time on appeal, which AFSL versus Commonwealth stated, and also that it can only be abrogated and waived by the legislature through a policymaking authority act, that it is the subject matter jurisdiction that matters here.
But what do I do with the Virginia Supreme Court in 2022 saying we haven't answered the question of whether it's personal jurisdiction or subject matter jurisdiction, and we need not do so here, right? And I mean, you know, we're charged, I think, with anticipating what the Virginia Supreme Court would say in this context. And I've got conflicting messaging, right? Asphalt seems to suggest it's subject matter jurisdiction, right? You then have at least the question being held open in Farmer. And so I'm not sure what to do with that, right? Does that open it up for us to try to figure out and really just anticipate what the Virginia Supreme Court would do?
No, Your Honor, I don't think that this court needs to anticipate what the Virginia Supreme Court needs to do. I think it just looks at AFSL versus Commonwealth and it's held. And also with McManama is clear in the non-suit context, putting those two together, that sovereign immunity deprives the court of subject matter jurisdiction, which then deprives the court of the ability to issue a non-suit order with the tolling effect in subsequent proceedings. And I would also like to turn to, I guess, the benefits of a non-suit order in Virginia courts. The first benefit that a litigant would get is the dismissal without prejudice, and that's a true tangible benefit. Massey in this case received that benefit because in the state court proceedings, the sovereign immunity issue was completely briefed in full, and the court actually had calendared a hearing on that issue right before Massey took that non-suit. And it makes sense that a subsequent court, that we're dealing with the collateral effect of tolling in this case rather than through appeal or in the trial court, because there's no requirement in state courts in Virginia to address the sovereign immunity or subject matter jurisdiction issue to issue a non-suit order.
Wait, say that one more time. There's no requirement that they address
the sovereign immunity plea or the subject matter jurisdiction issue before issuing a non-suit order. And that makes sense because a non-suit order is not a decision on the merits. It's simply a dismissal without prejudice, much akin to a Rule 41A voluntary dismissal. So it would just make sense that a court, the trial court, would not decide the sovereign immunity issue and why we're dealing with it in the subsequent filing in federal court.
So we're court that doesn't have subject matter jurisdiction can enter an order.
I'm sorry, Your Honor.
Court that does not have subject matter jurisdiction can enter an order.
In this case, It is called a non-suit order, but it's equivalent or analogous to in Virginia, a Rule 41A dismissal where you don't address the subject matter jurisdiction issue. There's matters lingering before the court.
Wouldn't we in federal court under Steel Code, wouldn't we have to address our subject matter jurisdiction? And maybe that doesn't apply in Virginia, but you keep bringing up Rule 41. Like, could we issue a Rule 41 order where we had a pending subject matter jurisdiction motion? It seems like to me Steel Code would tell us that no, you've got to address jurisdiction before you address a Rule 41 motion, right? That's the sort of order of operations that we have.
I think where the parties under Rule 41A, it is not a Rule 41A dismissal, but it's.
I know, but we're analogizing it. And so I'm trying to play that out in federal court. I don't care if the parties agree. The point is, if the parties agree to Rule 41 and I lack subject matter jurisdiction, I can't grant a Rule 41 motion. That's what Steel Code tells us. We've got to do jurisdiction first.
I think in Virginia, there's no requirement to resolve that issue beforehand. And it makes sense because it would be a waste of judicial resources to require a court to first address that when the plaintiff has taken
it's often a waste of judicial resources to decide whether we have the power to make a decision before making the decision. But the very nature of a court is that it only makes decisions where it has that power. So what is the source of your position that Virginia approves its trial courts making decisions where it lacks the power to do so? Like has the Virginia Supreme Court said that its trial courts can make decisions without jurisdiction?
No, we're not pointing to any Virginia Supreme Court.
So where is it? You keep saying in Virginia, if you're a trial court judge, you can just make decisions. You don't have to decide whether you have power to do so. What's the basis for that claim?
I don't think we're broadly saying that Virginia courts can decide anything before they decide whether they have the power to do so. I think in the context of the non-suit order in the statute, it tells the court to simply dismiss the case on the plaintiff's motion. And those are the requirements.
Right. So what's the authority? Help me understand what I look to. If I wanted to write the sentence that you've given in an opinion that says there's no requirement, I'm trying to quote you, but you can rephrase it. There's no requirement that a Virginia trial court address a pending subject matter issue before granting a non-suit. What am I citing for that proposition?
I think you would be citing, one, the fact that state courts have said that non-suits, plaintiffs have an absolute right to a non-suit. You would cite also the statutory text that requires a court to simply dismiss on the plaintiff's motion unilaterally.
But why do either of those support the proposition, right? You can have an absolute right to something, but you still have to have jurisdiction, right? Like neither of those seem to support the claim that the Commonwealth is making, that a trial court judge can ignore a subject matter motion in order to grant a non-suit without the power of jurisdiction. I mean, it just seems like a remarkable claim for the Commonwealth to make.
I think to put it into context, a court would not examine whether that issuing court had subject matter jurisdiction until after the fact, because you would only examine that fact where you look at whether tolling applies and you're looking at if that non-suit order would give you tolling. That's when you peek at the motions and determine.
But that suggests to me that you're actually saying that the trial court has the power to grant the non-suit. I mean, that's his argument, right? You're saying, no, you don't have to address the subject matter. You can just issue the order. Right? The trial court just gets to issue orders. Power or no power, doesn't matter. Just issue the order.
I think on the plaintiff's motion, the trial court has the ability to simply dismiss. Yes.
Simply dismiss. I don't know what the word dismiss means there.
Dismiss the case without prejudice.
Grant non-suit. You mean
Correct.
grant a non-suit or do you mean dismiss?
That's what granting a non-suit does. It's simply dismissing it from the docket on the plaintiff's motion.
So you agree that the trial court had the authority to grant the non-suit?
We agree that on the plaintiff's motion, the trial court had the ability to simply dismiss without prejudice, correct, and grant the non-suit. We're simply,
Then what is your argument? Because that, if they had that power to do so, we tend to refer to that power as having subject matter jurisdiction, right? So if it had subject matter jurisdiction, then the claim is tolled because the non-suit tolls the statute.
we're arguing that that non-suit has no collateral effect of tolling the non-suit.
So
Or of
you're
tolling
agreeing
fees.
with the counsel on the other side as far as the non-suit argument.
Sorry?
You're
Non-
agreeing with counsel that there was a non-suit properly entered here.
Well, we're saying that that non-suit order, it does not address the merits. It's not a ruling on the merits. It simply dismisses the claim. So the court doesn't need subject matter jurisdiction to simply dismiss a claim there. But
So
it
you
does
have two
need.
different types of non-suit orders.
What?
Is that what you're saying?
No, I'm saying that a non-suit order is a dismissal without prejudice. It's not a ruling on the merits.
And you say that happened in this case.
Yes.
Isn't that exactly what he's arguing?
I don't think that he's arguing that a non-suit order.
That it told the statute? of
No, we're
limitations?
saying it would not toll a statute of limitations because the issuing court had no subject matter jurisdiction.
But you've just said that.
I think we're a little confused in terms of the direction you're going.
Yeah, can you go back to this point? So is there authority for the proposition that a Commonwealth court can issue a non-suit where it lacks the power to do so?
I think the authority that you look at, or I wouldn't call it authority, but to frame it in your honor's minds, it's simply a dismissal. It's not a ruling on the merits. So the court
All right,
doesn't.
so why does a Commonwealth court have the power? You can call it authority, you can call it subject matter jurisdiction, you can pick your word, but how does it have the power to dismiss a case where it lacks that power? I mean, that your argument seems to just be a circle, right? Either it has the power to issue the order or it lacks the power to issue the order. We call that subject matter jurisdiction, we call it authority, we call it power, it doesn't matter to me, right? But either it has that authority or it doesn't. And you've suggested to us repeatedly that it has that authority. If it has that authority, then it tolls the statute.
Well, for our case, our purposes, we're not saying that the court was correct to grant the non-suit. We're saying that there's no tolling and it did not need to reach the question of jurisdiction.
All right, one more time, can you explain to me why it did not need to reach the question of jurisdiction?
It did not need to reach the question of jurisdiction because the ruling was not on, there was no ruling on the merits.
And your view is that a Commonwealth court can issue any ruling it likes so long as it's not on the merits.
Our position is here that the court was correct to
All
grant
right,
the
so
non-suit.
rephrase the question. Can, in the Commonwealth's view, a Commonwealth court issue any order it wishes so long as it does not address the merits?
I don't think that we are addressing that question.
I'm asking the question. And so that's the question I'm asking.
Mhm. I think what we're saying is in this case,
I understand in this case, I'm asking the question though, right? Is the Commonwealth's view that a Commonwealth court can issue any order it wants to as long as it's not on the merits? That's a totally reasonable position, by the way, right? I mean, there's a theory that says, listen, the subject matter power of the court only goes to adjudicating the merits. And as long as you're doing ancillary or preliminary matters, right, that those issues can be done separately, right? You think about forum non-convenes in the Steel Code context. Totally a reasonable view. I didn't understand that to be the Commonwealth's position, but that's what I'm trying to understand.
Mhm.
Is that your position? Is your position that subject matter only limits the power of a Commonwealth court to issue a decision on the merits? Or does it also limit the power of a Commonwealth court to do ancillary matters such as grant a non-suit?
we're taking the position that it does not prevent a court from issuing ancillary matters. So not having subject matter jurisdiction does not.
Look at your brief on page 17 and 18, where you say the non-suit order was void ab initio.
Mhm.
What did you mean?
We were taking that from Singh v. Mooney. The Supreme Court of Virginia has held that order.
That's not what you argue today.
You're telling us the opposite now.
Well, we're talking about the effect of the non-suit order. That's the main question in this case.
I don't know where that distinction lies.
The
If it's a
distinction,
non-suit order, it has an effect. Total
well, a
statute of
collateral
limitation.
effect. In
Has
the
that
subsequent
effect,
proceedings.
and you say the court, the fact that it lacks subject matter jurisdiction, and that arises from the fact if you got sovereign immunity to the Rehabilitation Act claims, then the court lacks subject matter jurisdiction.
Correct.
If you start with that basis there, but you say you don't need to get there. The court doesn't even need to decide that. They can just go ahead and grant a non-suit order, which is what the other side is answering, pursuing, because if it can grant a non-suit order, then it leads you to the conclusion a non-suit order would toll the statute of limitations. Therefore, he's in court proper. So I don't know what this collateral business is or the effect of it in terms of the non-suit order. That sounds a little complicated even when you're dealing in a Rule 41 perspective. I don't know this distinction of the effect and all of that, but a non-suit order is a non-suit order. And if it's a non-suit order, then it tolls the statute of limitations. Especially if it's without prejudice. There's a reason without prejudice in it. So where is this going? I'm not.
Well, the reason that it's without prejudice, it gives the party ability to start on a blank slate, but that doesn't necessarily mean it gives the party the ability to toll the claims. I think it's two separate effects.
Well, but if it gives the party anything, so if the court had the power to do it, we know that it gives them tolling, right? That's what the statute says. Like, if it's a non-suit order, it tolls. The question we have is whether it's a real non-suit order.
In other words, the statute of limitation runs out after it comes. You got that tolling period because it says without order that allows you to come back with it.
So a couple of things, Your Honor. One, we're not saying that the court was correct to grant the non-suit. We're not saying that. We're saying that it didn't have to reach the question of jurisdiction. The other part the issue that we're discussing is that the non-suit order had no tolling effect because when the subsequent filing happened, you look back at the non-suit order or the court's action and you determine whether it was, as we said, valid and whether it has a tolling effect. And I don't think the statutes necessarily get us all the way there, but the Supreme Court of Virginia has in McManama v. Plunk, where it discusses that without subject matter jurisdiction, the non-suit order does not toll the proceedings or toll the claims.
Judge Straxler, do you have any questions?
No, thank you, Judge Wynn.
Thank you for your argument.
Thank you.
Your Honors.
I'm going to assume you're going to start by adopting her argument.
Yeah, there's some points to it that I agree with. As it relates to the Asphalt case, Your Honor, that matter, it characterizes subject matter jurisdiction as the ability to adjudicate a matter. Virginia courts have held that a non-suit is not an adjudication of the matter. Therefore, you can draw a line between these two things.
Which is the point she was just making, right? She was arguing just that, right? That you can't do the merits, but you can do anything else you want to.
What I heard my colleague say was the court doesn't have to reach the issue of jurisdiction. In other words, that the order can just be entered. And if that's the case, then the order is entered and tolling applies. This is a case in which all of the statutory prerequisites of the non-suit were met. McNamara says that a trial court may not place limitations on the plaintiff's right to the voluntary non-suit which are not found in the statute itself. The Supreme Court of Virginia has not affirmatively, clearly established that the plaintiff is barred in this case. And for that matter, this matter must be reversed. The plaintiff timely filed, he followed all the prerequisite steps. The court had the authority to issue an order dismissing it without prejudice pursuant to the non-suit statute to allow the plaintiff to refile. If you have any other questions, I'll read.
Judge Straxler, any questions?
Thank you.
Well, thank you. Thank counsel, both counsel, for your arguments today. We will come down and greet counsel and adjourn court until tomorrow, until the ceremony session this afternoon.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.